My name is David Duffy, and I'm a partner in Thompson Coburn's Business Litigation Group. My practice involves the resolution of complex commercial and product liability litigation, and I've resolved and litigated complex eDiscovery disputes and assisted clients with litigation preparedness plans for their electronically stored information. My co-presenter this afternoon, Jennifer Bauman, is counsel at Thompson Coburn, and she emphasizes eDiscovery as the primary focus in her practice. Jennifer is a frequent speaker and writer on eDiscovery issues, and she consults and manages complex eDiscovery projects for our clients and provides other eDiscovery consultation. Today, we're going to focus on cloud computing and eDiscovery. We've broken this presentation into three discrete parts. The first, I'm going to talk briefly about cloud computing, as we all, I think, are beginning to understand the issues, but I want to make sure we have the right terms to define our discussion. Then we're going to spend the majority of the discussion about eDiscovery consideration. First, I want to talk a little bit about the 2015 amendments to the Federal Rules of Civil Procedure and how that applies to cloud computing and eDiscovery. And then I'm going to turn the presentation over to Jennifer, and she's going to discuss cloud service providers and whether they're actually ready to help you with your eDiscovery issues. Have you looked at your service level agreements and what's actually in them? And we're going to conclude by talking about bring your own cloud, which, you know, anytime lawyers hear bring your own anything, it raises interesting questions, and Jennifer has got some interesting discussion around that. So when we talk about cloud computing, I pulled this, lengthy definition from the National Institute of Standards and Technology, and you can read that. But what really is important, I think, to understand is that if we are getting on-demand network access to a shared pool of configurable computing resources. And that means a lot of things. It's a big mouthful, but what really it means is we're able now with the cloud to take what was the entire backbone of an IT organization at a company, and we're able to put it outside the corporate walls. The result of that is a lot of benefits to the company, and we'll look at that here in a second. When I look at the benefits that we talk about with cloud computing, we're talking about IT componentization. In particular, this ability to outsource your hardware, your software, your services, your storage, operation, maintenance, and all of your upgrades. As we constantly are barraged by data security issues, which is not a subject of this particular presentation, we recognize, or corporations have recognized, that maybe it's better to outsource a lot of the IT functions to try to stay ahead of data security, to try to make sure that your infrastructure is supported at all times, and that you have sufficient redundancy. For a lot of companies, you just simply can't afford to maintain that level of service in-house anymore. It's too expensive. So the reality is the finance people like the cloud, and the IT department likes the cloud. This slide references the same points that we're making with respect to what we're going to do and how we're going to get benefit from the cloud. Now, what I would say is, since the finance department likes it and the IT department likes it, if you're a litigator or you're an in-house attorney, that may mean that you don't like it, because it always seems that when finance and the IT department like something, it creates new challenges for litigators and for in-house counsel, and this is certainly no exception. So how do we deploy clouds? And I don't know that everybody understands fully what it is, because we're users of the internet, we're users of cloud services, and we often think of the publicly available clouds. So think of Gmail, Google Docs, think of any of the applications that you're accessing in the web, like Twitter and Facebook. That's a public cloud. Those are services that are being made available to the public at large. There are also private clouds. Individual businesses, or individuals for that matter, actually obtaining space outside the four walls of the organization to perform this IT function that used to be typically done in-house. There are community clouds where multiple organizations pull resources directly together to go create an IT infrastructure outside the four walls of the organization. And then, perhaps most challenging from an eDiscovery perspective, there are hybrid clouds which mix all of this together and create a variety of applications that businesses and individuals within businesses are interacting with at any time where data may be kept. I've been talking about eDiscovery and cloud issues for years. And we've all been talking about those issues for years. But what's fascinating to me is as we evolve into cloud discussion, in the last 5 years, how much additional buy-in of organizations there is in the cloud. 93% of respondents in a 2015 RightScale survey of 930 IT folks acknowledge that they are using the cloud in their businesses. And that's not surprising. Marketing is using Facebook and Twitter as much as anything, even if they haven't outsourced all the IT functions. But when you look at this survey, what's fascinating to me is how many businesses are deploying multi-cloud type uses in the business. Now, that could be simply using an application on the web and then outsourcing other IT functions, but that's the point. As lawyers in-house and out-house, we're going to all have to understand how this data is being used, what the company's interactions are with these cloud services, and what that might mean to our obligations. You probably heard these terms, at least you've heard the first one, which is what's commonly referred to as SaaS, software as a service. These are the types of clouds, the actual service models. Facebook and Twitter are an example of a SaaS. It's software as a service. When you interact with those applications, you are actually interacting with an application created by someone else, made available to you. That's software as a service, which I think is predominantly how most of us are interacting with the cloud. But what you may not know is that gone are the days in your organization where there used to be all these big server boxes sitting around with data rooms and air-conditioned data rooms and a bunch of people trying to make sure those things are running all the time. Well, they've outsourced that. Platform as a service and infrastructure of a service have come in to become the IT backbone. So now we can develop applications outside the four walls by simply being able to access database engines that you used to have to license and pay for yourself. Now you can actually license it from the third party, get access to those engines, and create the same applications you would have created, but gone is the big room with all those server boxes. So we're moving on now, and let's talk about the eDiscovery considerations and the legal framework that we need to have our discussion today. Do the old rules apply? Well, I hope everybody on this call is aware of the changes in the rules, and I think most people are, although it's strange when I read an opinion and see that lawyers often still don't know that the rules underwent a seismic shift. And we're talking about the Federal Rules of Civil Procedure and the 2015 amendments. In law school, certainly when I went to law school years ago, we talked a lot about the standard for discovery being whether information is reasonably calculated to lead to discovery of admissible evidence. Well, that no longer exists. In the new Rule 26b1, we talk about something I think that's frankly more rational, which is whether discovery is permitted is based upon whether the requested discovery is relevant and necessary to a claim or defense in the litigation, and whether the requested discovery is proportional to the overall litigation, which is really an important additional concept that courts now are introducing. And the proportionality test looks at factors like the importance of the issues at stake, or the relevance of the discovery to the issues at stake, how much is actually in dispute in the lawsuit, the parties' equal and relative access to the information being sought. When we look at the resources of each party, is one side much larger financially than the other side? We look at the importance of the discovery being requested. And then I think in an eDiscovery way, we always are going to look at the burden or expense of discovery and whether it outweighs its likely benefit. So this is a whole new tool of arsenal that I think lawyers that are familiar with eDiscovery issues have been making for years and trying to get courts to buy into it. Well, now we've institutionalized a new set of rules that really give us the ability to argue the value of particular types of expensive discovery. One important tip for all the practitioners is that the case law that is being developed reemphasizes, as the committee amendments themselves expressly state, is that there is no such thing as a blanket or generic non-proportional objection. Objections have to be specific, and you actually are going to have to make evidentiary showings to meet your burden to resist discovery on the basis that discovery requested is not proportional. So just a tip for takeaway, because we are already seeing cases where courts are just simply striking down generic objections that can't be supported with an evidentiary basis. secondarily is 26B2B, which is embedded within the idea of protective orders and the way we used to always seek protective orders. Now the rule will limit discovery of documents and electronically stored information if that information is not, quote, reasonably accessible because of undue burden or cost. Now, as always, the court retains flexibility to permit such discovery if there is good cause. But I think it's really important to realize that the courts are giving us this avenue to make these objections. What is important to note for cloud computing, however, is that when the cases have talked about reasonably accessible information in the eDiscovery context, they are talking about information that is not available on demand. It tends to be the information that is no longer accessible, may be disaster recovery, may have been put into an archival format, and is in itself data that is not readily available to be produced. The Facebook application you're interacting with, or the application for your sales data that is now being outsourced as a third-party cloud, that is available information that is available arguably on demand. So this doesn't fall within the 26B2B category. And so we're back to our proportionality objections and whether it's proportional to require specific discovery take place. So anybody that's worked in eDiscovery, and all of us have been, I'm sure, to many presentations on the subject over the past 15 years, the same rules apply in cloud computing cases that applied in eDiscovery as we work through the case law. And like any part of this change in technology that is rapid, the courts and the case law is lagging behind. So you're still out here in cloud computing and eDiscovery. You're out in a frontier that is still the frontier. We don't have a lot of recent cases talking about burden and talking about the difficulty with accessing particular types of data. So let's start with our first principle, that your eDiscovery principle should apply. As lawyers, as in-house counsel, we need to understand our client's data. We have an obligation to understand the data that may be relevant in the course of a litigation, and we have the obligation to be constantly reviewing that as the litigation progresses to make certain that we are doing the right steps to preserve relevant information and to collect and produce information that may be discoverable. It's as simple as that. It hasn't changed, but now we have to look at it in the framework of whether the legal requirements for the production of discovery have themselves changed in some way. As we found in the development of case law, and I do a fair amount of product liability work, the ability to access Facebook, the ability to access private social media sites of individual plaintiffs in litigation has proven to be a boon for the defense bar and our ability to attack damages and to present new avenues of defense. So we're already very familiar with requesting material, but when we request it from the plaintiffs, and the case law that's developed has certainly suggested that the plaintiffs have to produce, at least within reason, data that they may be keeping on social media sites where damages are relevant to a case, or their medical history is in play, or some other particular issue. No doubt, though, the same rules apply in company applications on an infrastructure where the company's sales history or finance history is just being maintained off-source or off-site. Rule 34A requires that a production of electronically stored information be made whenever the information being sought is within the party's possession, custody, or control. This hasn't changed. This is the same language the rules have used for years. So when we look at that, the question is cloud data in the respondent's possession, custody, or control? Well, it's pretty clear, I think, that the cloud data is not in the possession or custody of a particular party. It's not within your four walls. It's not the corporations in the physical sense. So the question is really control. And in the context of control, I cite to the American Rock Salt Company versus Norfolk Southern case. It's at 228 FRD 426. Case out of the Western District of New York in 2005 defined control for purposes of 34A as the legal right, authority, or ability to obtain upon demand documents in the possession of another. Well, that should be a fairly straightforward principle to apply in the cloud computing context. And what little case law that's developed, I think, gives us some roadmap and some guideposts as to how we can look at that. The first case I would suggest that we consider is the question of ownership of data and whether that plays into whether there is actual control. The case I cite is Procter & Gamble versus Hagen. You have the site here, and essentially that dispute involved Procter & Gamble suing a commercial dispute, and they were making a lost profits claim. And their lost profits claim based upon market share and market information for this particular product, they actually gathered information off of their market data research subscription site, which is IRI, who's a leading provider of market research for consumer products companies. So they collected data, they exported some data from IRI, they produced that data, and the defendants were not satisfied. They wanted a far greater inquiry and actually asked to broadly require that that Procter & Gamble produce data that IRI had with respect to market research. Well, the court correctly went to the contractual level in analyzing whether Procter & Gamble would have such a duty. Even if the information were relevant, the court looked at Procter & Gamble's ability to access data and concluded that it was not the owner of this data. It had a limited ability under a subscription agreement to access data under a license or under the terms of that subscription. It never owned any data. It was accessing data, if you will. And therefore, the court found that and I think correctly, that P&G did not control the data for purposes of a broad production of data to the other side. Now, they had to wrestle with the issues of what that meant in the context of the litigation, but on its face, that's the right result because it would be argued that Procter & Gamble did not control the data. IRI controlled the data and limited how that could be used or disseminated. By contrast, a group of cases have come along developing, I think, what looks like the body of cloud computing law. And I cite the Kaiser versus Pride Communications case. That can be found at 2011 U.S. District Lexus 124124. It's a 2011 case in which, in that case, the court rejected a defendant's attempt to refuse the production of payroll and time clock records that had been outsourced to a third-party provider of payroll services. There, the court said, no, sorry, you actually have control over that information that you've been funneling to that third party. You have to make a demand to get that information and actually produce it. Now, I can imagine that myself, I would have tried to litigate the question of whether I actually had control, but I think the courts look through it now, or at least there's a body of case law that suggests the courts would look through that and require me to produce that. More pertinent to our particular discussion is the Brown versus Tellermate case, which is frequently cited in eDiscovery articles. It can be found at 2014 Westlaw 2987051. And in that case, the Southern District of Ohio looked at a real SaaS situation. There, Salesforce.com, which you may know about, is one of the largest CRM providers, customer relations management software providers. For Salesforce, it tracks your marketing efforts, makes sure that it tracks sales hits, and kept real data on sales results. Well, for this particular case, it was an HR case in which the company was defending a termination based on the poor performance of the employee. Well, the employee wanted to compare their results to other results of other like employees, not an unreasonable or unexpected type discovery request. The defense lawyers attempted to defend the case by arguing that they had no control over the data. Salesforce had complete control, and therefore they were unable to access it. They did not take steps to preserve it, and they did not produce the Salesforce.com data. Ultimately, that was entirely rejected by the court, and sanctions were issued for a variety of missteps, but the sanction was the company was precluded from defending the case on the basis that the employee's termination was based upon poor performance. And the reason was because, like any cloud service, they were regularly changing the data in that database, and they weren't preserving it. They preserved it for 3 to 6 months. Well, nobody looked at that at the outset of the litigation and made steps to attempt to make sure that data was available. So I think that's a really strong case if you look at your obligations as in-house and outside counsel to start thinking about where we go with the future of cloud computing and eDiscovery. So now I'd like to turn it over to Jennifer, who's going to spend the rest of our discussion talking about our cloud service providers and how they fit into this. Now that we know we've got some control over data, how are we going to get the data and what are we going to do with it? Jennifer?
Thanks, Dave. So when we're looking at our considerations, we need to know whether our cloud service provider is ready. But first, I'd like to note that it's important to remember that while eDiscovery has its own unique characteristics and issues that need to be addressed, at the end of the day, it's still discovery. What we have to figure out are where are the things, the documents, the data, and the information that's relevant to the claims and defenses and proportionate to the needs of our case. What filing cabinet is it in? Physical or electronic, on-site or off-site? Those filing cabinets are just larger and seemingly endless in this electronic world. So when we're looking at our cloud service provider, our IT department, the financial guys, are probably looking at the cost, the security, and the accessibility when considering that cloud service provider, but perhaps have not looked at electronic discovery or consulted other shareholders. So have they consulted with your privacy, HR, and litigations teams for potential issues related to your eDiscovery and that you need to raise at the outset of your agreement? One of the key aspects in being prepared for eDiscovery is knowing where your data is stored, how can it be searched and collected, and often under a short period of time. When looking at your cloud service provider, you really want to look at how much experience have they had with eDiscovery, whether that's with litigation, internal investigations, government inquiries, or subpoenas. Have you inquired with their ability to handle eDiscovery? What is their history with it? Are they willing to give you referrals or recommendations? Can they answer and document this experience for you? Additionally, how transparent are they willing to be with their capabilities? Are they willing to let you verify and test drive the system so you know what they claim to do actually works? If you do test it and it doesn't work as it's supposed to, is the service provider willing to work with you in order to either fix the issue or figure out some sort of workaround? Are they able to handle this eDiscovery? And once you're in litigation and in discovery, will they provide you a point of contact? Will it be the same point of contact? How accessible are they going to be so that you know what their process is, so that when you're partnering with them, you're not left hanging on what the process is going to be? So really what we're going to be looking at here is the service level agreement that you enter into with your provider. And really the time for addressing this is when you're vetting your service provider and negotiating to the extent that you can your service agreement. And if you can't do this before looking at it, take a look at what you have agreed to. Is it addressed in your agreement? Is it something that you can go back and talk to your vendor about? Really, we need to focus on the areas of the agreement so that we know in advance of litigation what issues need to be addressed before they arise. Some cloud service providers may not be willing to negotiate. If they won't negotiate, consider what issues are in their agreement and whether or not you can live with what they have in there. Also figure out if there's something that you can negotiate. Are there provisions that you can negotiate related to a legal hold or data collection? Better to know these things up front. So when we're looking at our service level agreement, the things that we should be looking at are the data location, data ownership, data searching, policy implementation, litigation holds, data retrieval and collection, and data loss. Several of these things might overlap, but we've tried to break them out here into distinct points for your consideration when you're looking at your agreements with your service provider. Now, as we've talked about, under the federal rules, you have a reasonable obligation to identify, preserve, and collect relevant information to the claims and defenses that's proportional to the needs of your case. As Dave has already talked about, it's likely that this information is within your control once it's in the cloud. So we really need to look at what's in our agreement and what are the obligations and responsibilities of the parties underneath those agreements. Understanding how and where your data is stored and how it can be accessed will make litigation run a lot easier and smoother and quicker. It will also be able to help you in understanding how you can form your objections to whether or not your data is accessible and to whether or not there's undue burden and cost. Let's talk about data location. It's important to have a data map. A data map is simply a document that is kept that is either a visual or written description of the format and location of your data, how it's stored, where it's stored, what the backup procedures are, and how your records management policy impacts your map. A well-kept data map, usually kept by your IT personnel as the experts in your IT systems, as they have set up your accounts, your email, your networks, your drives, etc., is vital in identifying relevant ESI and litigation and other responses. A data map should be a living document, updated as your system changes and updated as you add additional resources and take additional resources offline. It provides a guide to where your email programs are, your word processing documents, databases, and how they're used, backed up, and managed. However, data in the cloud complicates this map, particularly when you're using multiple clouds. And I say it complicates your map because the data is no longer maintained, hosted, managed on servers and networks owned by the company. It's harder to map where the data is located, backed up, and accessed. So really, your map should contain where all your cloud service providers that you use are, and identify all the locations of the data in the cloud. Where is your provider physically locating those servers? Where are your backups physically located? How are they formatting and archiving your data? Are they using any subcontractors that you should be aware of in backing up or archiving that data? And if the data is being backed up by the subcontractor, who is it? Where are they storing it? You should also consider whether or not you have the right to audit your contract service provider and whether they have the right or the ability to audit any subcontractors. Other important considerations at looking at where your data is being stored is how it implicates potential data and privacy laws if that data is being stored in another state or foreign jurisdiction that may impact any export of that data. Also, you should consider what types of data are you storing and where is it being stored. Is there particularly sensitive data that you don't want stored in a particular place or with a particular subcontractor? And what process determines how data is stored? If your cloud service provider is moving it across or copying it across jurisdictions, what process ensures that complete and accurate data can be accessed in a controlled fashion? Let's talk for a minute about data ownership. Of course, you should own your data, but what happens if the cloud service provider is acquired or sold? Can you migrate your data out of the cloud to another cloud or another system? Does the data evaporate? What happens to your agreement in terms if it's acquired by another company? How much notice should you be given? Does your agreement provide for any of this? And are you looking into these issues when you're negotiating your agreements with your cloud service provider? What happens if they declare bankruptcy? Can you migrate your data out? Can you purchase the machines housing your data? Will there be any delay in obtaining access to your data, or can you obtain information from a backup? Additionally, what happens if your data is breached? Has it been compromised? Is the cloud service provider required to migrate to a new cloud or provide an audit? All of these scenarios cause for quick and potentially expensive decisions to be made. How does this impact your control of the data, the chain of custody, and responding to your discovery? What process is in your agreement that governs the preservation and return of the data in these potential scenarios? Knowing these answers before you're in litigation will help prevent issues when you're in the middle of litigation. So let's talk for a minute about data searching. Searching is an important issue in eDiscovery because you're going to want to be able to quickly call through and locate potentially relevant data and documents without having to export terabytes of data. Putting these issues at the forefront helps you understand in talking with your vendor about what tools are available to search your data. Consider asking them, what are the available analytical tools that can search your data? What tools and rights do you have to using those? Are the tools available for someone within your enterprise to access administratively, or is it only available to somebody at the cloud service provider? If you have to go back and ask for the help of the cloud service provider, or if you're getting access administratively, what are the associated costs for using these tools, and who is going to bear these costs? Additionally, you might want to look to see if any of these tools are compatible with your regularly used or in-house eDiscovery tools. So while putting the data in the cloud might be easier or cheaper, it makes things more accessible in terms of portability of the data. If you don't know how you're going to be able to search it once you're in litigation, It doesn't do much good if it's there but you can't get at it. An additional issue for considering with data searching is data encryption, and knowing if your data has been encrypted by the cloud service provider or if you've used some sort of middleware application before it reaches the cloud. You'll want to know what those encryption processes and tools are and how searching and collecting that is impacted by that encryption. Additionally, when we're talking about searching, you want to know who else might potentially be able to search your data. What happens if the cloud service provider receives a warrant or subpoena for information? Does your agreement outline if you'll be notified, how and when you'll be notified, and what happens if your data is commingled with somebody else's data that is being searched? So turning now to policy implementation. When we're looking at policy implementation here, what we're really looking at is record management and our record retention schedules. So our record management policy identifies that information that needs to be retained as long as it has value to your organization or as long as it's required by law or regulation. So when we're talking about dealing with our cloud service providers, how does your company's document retention policy and schedule address storage of data in the cloud? How is it addressed, how is it implemented, and how has your policy been updated to account for that? Additionally, you want to ensure that the cloud service provider has the ability to follow your record retention policies and schedules. Having the policy will do no good if the cloud service provider cannot also ensure that there's a way to carry that forward. And then we'll want to look at what the cloud service provider's record retention policy is. How do they maintain their data, and how do they dispose of it? And then how do they reconcile their retention policy and schedule with your own? You want to make sure that you're not in danger of losing any of your data that you have put out there because they have some sort of retention policy or schedule that puts that in danger. Additionally, you'll want to make sure that if you have a retention policy that calls for destruction within accordance with that policy within particular periods of time, that the cloud service provider still doesn't maintain some of that data so that even though you believe that it has been destroyed, there's still a copy being maintained somewhere. The next consideration is a litigation hold. So the issuance of a litigation hold is important once you reasonably anticipate litigation in order to avoid potential spoliation of data. The duty to preserve requires the party to be able to identify, locate, and maintain information and tangible evidence that is relevant to the specific and identifiable litigation. So your duty to hold information may arise months or years before litigation actually begins. And there's been cases where courts have found that that duty went back a year or more depending on the facts or circumstances in the case. Particularly consider if you're usually a defendant in a case but are contemplating initiating litigation. Once you start contemplating that litigation, you may now have reasonably anticipated litigation and need to issue that hold within your organization. So when you're looking at your litigation hold, you'll want to know if your cloud service provider will agree to help implement that hold, and does your agreement with them detail how the litigation hold will be handled and executed. Will there be an automated process? Does it need to be a manual process? Is this something for which there's an administrative ability to issue the hold, or do you have to work with the cloud service provider in order to do that? Additionally, you want to know if there's periodic sampling or some sort of reporting or audit function that will help you know whether or not the litigation hold has been implemented. And you'll want to know what information you can get from such reports. When you're implementing that hold, if there's any subcontractors at issue, you'll want to know how does that reach down into the subcontractors. How is the data policies going to be suspended in accordance with that hold? And you'll want to know the detail of how a cloud service provider reconciles your litigation hold if your data is commingled with other data. And lastly, and we've kind of touched on this before, you'll want to know the costs associated with holding the data. Who's going to bear those costs, and what are those costs going to be for holding additional data beyond potentially what your agreement calls for? Turning next to data retrieval and collection. What you're going to want to know is if your service provider is able to precisely describe its export capabilities. Are they willing to put these capabilities into their agreement, and what mechanism is provided for making requests for exporting your data? You'll also want to know whether your cloud service provider is available to assist with the data collection and export, or if it's something that you will have administrative access to do. You'll also want to know what types of data can be exported. So if you're putting particular types of data in the cloud, you're going to make sure you can get it back out. And you're going to want to work with your cloud service provider to make sure that if you can't, is there a workaround? Is there something that's going to be workable for us in this situation? Again, you'll want to know who can collect this data and whether or not that's an administrative self-collection ability, if you have to work with the cloud service provider to do it, or do you need to reach out to a third-party vendor to be involved? And if you have to reach out to a third party, will the cloud service provider allow for it? You'll also want to know when collection can occur. Is it something that can take place during the day on a 24-hour cycle, or must it be scheduled after hours so not to interfere with any daily access needs? You'll want to know how your data export is being handled. Is it something that can be done in bulk? You'll want to know how much time does it usually take to download a gigabyte of data. Do they have to do it individually, which can take a long time if they have to individually export files? When metadata is uploaded to the cloud, is the file metadata stored separate from the file? If so, when you ask for an export, do you also have to ask for the associated metadata to be exported? You want to know about version control capabilities, as well as what happens when you have upgraded to different versions. You will also want to know if you have typical or internal tools, if the data types that are being exported will work with those tools. Again, in looking at this, you'll want to know who's responsible for the cost when you're looking at the preservation, searching, and collecting and exporting of this data. You'll also want to know how much time is it going to take to access this data and how much time is it going to take to collect it. If your service provider is the one who's going to perform the collection, do they give you a time period for how much time it's going to take them, days or weeks? And also, is there a limit on the number of times that data can be accessed under your agreement for this type of export? And if you go beyond that, what are the costs? You'll also want to consider format issues. Format issues can be important, especially in litigation when you're trying to reach agreement with the other side as to how it will be exported. So for example, if you're dealing with information that's in a database in the cloud, you want to know if it can be exported in a particular format, such as a delimited file or XML, so that when you're talking to the other side, you know how it can be exported. And lastly, you'll want to know, do you have procedures in place to quality control what's been collected? Can you do comparisons between the original file and the exported file, such as comparing hash values? Have you been able to meet the time frame for the collection? Is the formats what you needed? Was the metadata provided that you requested, and then the format that it was requested? Let's turn now to data loss. Does your agreement address data loss? What happens when software is upgraded or replaced? What are their abilities to recover the data if it is lost? And does the provider regularly test and back up its recovery processes? Are these made known to you? If they've lost data, what is their requirement to tell you that it's been lost? And looking at their disaster recovery, is it truly for disaster recovery purposes so that it would not be considered reasonably accessible? Or is it regularly accessed for purposes and making it reasonably accessible? When you're looking at your agreement for data loss, if it becomes inaccessible because of an outage, what is the process that is available to you for being aware of the outage and what it has affected? What is that cloud service provider's disaster recovery plan? What pieces of it are known to you, and how can it be tested? If the cloud service provider loses or is unable to produce data, will they indemnify you, including any potential discovery or related sanctions? So that kind of concludes our section on what to look for in your agreement with your cloud service provider. The last topic that we want to talk about is this issue of bring your own cloud, or BYOC. BYOC issues arise when employees have adopted on their own third-party cloud services outside the employer's enterprise. Much like employees might have the ability to save data and documents to external hard drives, thumb drives, disks, etc., it creates an endless cycle of tracking where the data and information can be. The question becomes, is it necessary to incorporate policies and practices to restrict certain ability to reach to sites on clouds or to particular clouds, or are there repercussions for employees in doing this? Employees often adopt their own cloud because they feel it's a convenient and easy use and low or no cost. So for example, you might have an employee who's working outside or working remotely, and they find that it's easier to access their documents by putting them up on Google Docs or Dropbox, much like they might find that it's easy to put it on a thumb drive. However, once they do this, it's outside of the company's data map, it's unknown to the IT department, and it's not subject to the company record retention and destruction policies. So this poses a number of issues. This includes security issues. Who has access to your data? Once it's on these kind of sites, do you know who's getting access to it? Where is it going, and where is it physically located? It presents eDiscovery concerns. Where is that data now located? And I know we keep talking about that, but if you don't know where it is, how can you preserve it, search it, and collect it? Additionally, you're now keeping data potentially beyond your record retention dates. And for information governance purposes, you can't manage data in accordance with those policies if you don't know where it's being located. And lastly, compliance. Is this data compliant with privacy policies? For example, if you have information that has personally identifiable information that is now being put outside of your known areas of corporate governance, do you have issues with your privacy? And so that brings us to the questions portion of the presentation.
Jennifer, as I've been sitting here listening to your portion of the presentation, I've come up with a number of questions, but particularly that's a lot of information about the SLAs and how we negotiate them. And I assume that in your experience, it's not real easy to negotiate, particularly with large cloud service providers, the terms of their SLAs. But if you could prioritize all of those bundles of information you provided, where should companies and lawyers, where should we be looking to try to get the most impact in a negotiation with the cloud service provider that would benefit us?
Right, that is a good question. And where I would probably look at in terms of prioritization is how are we going to hold the data? How is that litigation hold going to be put into place? How are we going to actually preserve the data? Because the data is likely going to be there, but we need to make sure it's being preserved, followed by how are we going to be able to search for it and then collect and retrieve it. And within all of those, I would probably look at how much time is that going to take and how much is the cost, and trying to spell out what those costs are for implementing the hold or having to search or collect those items as things that might be potentially areas that can be negotiated.
Let me follow up on that with one additional question then about the TellerMate case itself, which I know you're familiar with. And in the TellerMate case, again, I think one of the lessons remains that we need to all be asking the questions you're posing, because if the in-house team and the outside litigation team had asked those questions and understood what data was in this particular software product, they probably would have figured out that that data would be relevant in the course of litigation. So then the question is, what do I do? How do I get to the questions you just asked about litigation holds and whatnot? But there, the Salesforce.com site provided that there was no backup beyond 3 to 6 months. Are you saying that you expect there's some way I can get the cloud service provider to change that? Or how best would I deal with that in a litigation context where I have not previously gone through this exercise and we're just finding out about this data? What would your recommendation be in that circumstance?
Right, and I think it's important to remember is that there is no obligation unless it's required by law, regulation, or in the case of a litigation hold to preserve your data for particular periods of time. So if there's already something in place that says we're going to keep this for 6 months or 1 year or whatever the time period might be, that's perfectly acceptable within terms of those policies. And so what we'd have to look at and see, okay, what is the policy? What data do we actually have? And then work on figuring out how to collect the data that exists. We can't collect things that don't exist any longer, no different than if we had had hard copy documents that at one point had been typed up or printed off and put in a file, and we only needed to keep those for a year or 5 years and we're in year 6 and it's no longer there. And so I think that we have to start with that all data is not always going to be there, and it's perfectly in keeping with a business to have a workable policy, and that goes for our cloud service provider as well. Additionally, I think you have to look at the teller-make case particularly addresses, as counsel, we have to be competent. It raises our duty of competency, and there's a California ethics opinion that speaks to this that says we have a duty to know what technologies there are, and if we don't, then we should associate with someone who does, and if we don't want to do either of those things, then we should decline the representation. So it really behooves all of us to become familiar or associate with individuals who are familiar with these technologies. So once we know that it's there, we just have to figure out how we identify it, how we preserve it. And that might mean working with the provider themselves or working with a third party who might have to come in depending on what the data is. And I think we have another question here is regarding standard definitions of metadata and what needs to be determined in the licensing agreement. Now, in terms of looking at the metadata, I think part of that is going to depend on what type of data you're putting in the cloud to start with. If you're only putting a particular type of data, it might be something that you can identify the metadata that you're going to want to make sure can be exported. Where you're dealing with multiple sources of data that might have different types of metadata fields, it might not be as easy to put it in your agreement, except to say that you will want metadata available. Additionally, you might want to see if there's agreements that can be made further down the road if you know that you're putting a particular product online in the cloud to see what could be exported from that. So we've provided to you here our contact information if there's other questions or issues you'd like to follow up with us on from this presentation or related to electronic discovery. But we thank you today for your participation in this CLE.